change of topics as we're going to be looking at municipal dissolution. And we're happy today, I think everyone's outside the door, they'll be coming in here shortly, to have Mark Gorgos with us. He's the managing partner of Coughlin and Gehart. Mr. Gorgos' practice concentrates in the areas of commercial law, municipal and education law, public sector labor law, and credit bankruptcy matters. He's a primary attorney for a number of municipalities and school districts in the southern tier. He served as moderator for the U.S. Bankruptcy Court for the Northern District of New York and as an arbitrator for the 6th Judicial District of New York. He certainly is very present in the Broome County area with the Bar Association. He's past chair of the New York Conference of Bar Leaders, involved in several aspects there. And he currently serves as a member of the Albany Law School Government Law Center Advisory Board. He also, if you're interested in a little bit of some ideas on soccer, we understand he's got some soccer background and being coached for many years. So, but we have a surprise today, and we have a little added bonus today. Much of what we'll be talking about has to do with the time Stan Lundeen spent with the Lundeen Commission, for the state of New York around this topic. And Stan is going to join us today and give us a little kickoff to our conversation. Stan?
Thank you, Randy. I don't know whether I'd call it a bonus, but actually, I filed as a retired attorney, primarily so that I didn't have to go to CLE sessions. But when then Governor Spitzer asked if I would be willing to chair a 15-member commission on local government, I agreed to do that, and from April 2007 to April 2008, we had a great commission. We had an understanding that unless 10 of the 15 of us agreed to something, we wouldn't report it as a consensus. There were disagreements. In fact, I dissented on one. I guess that's in accordance with the great Jackson tradition. Some of his great opinions were actually dissents. But we did come out with a report that I think is gingerly on the shelf. I hope more of it will be taken off and revisited in the next legislative session and with the next governor. Everybody's talking about reform in Albany, but if you really look at it, you have to look at the combination of state policy, and particularly state taxes, and local, because it doesn't do very much good for Albany to lower rates and then create pressures that increase them at the local level. And as you all know, we really have a crisis with regard to property taxes in New York. I think it's the number one thing that makes us a challenge to be competitive. Chautauqua County, for example, was recently reported to have the 4th highest property taxes in the United States of America. And I just don't think that we can successfully retain and attract business and investment unless we change that. And it can't be all just at the local nor all at the state. I think there has to be a combination. And I'm delighted that you're attending this session today. I know that you're looking forward to learning more about hockey and more about municipal consolidation, but in the meantime, you're going to get some real expertise on that subject. And I'm particularly interested myself in facilitating school district consolidation, particularly in the rural areas. I think it's very clear that we have declining enrollment, increasing taxes, and buildings sitting half empty. And not only can we save taxpayer money, and mitigate property taxes. But more importantly, I think we can give young people better educational opportunity if we can combine, and there are limits to distance learning and that kind of thing. So I think that we need to pay particular attention in that area. Today, I think you're going to be focused more on municipal, and I personally believe that's very important too. I do believe in democratic, small d values, and I think it is important that people generally be allowed to vote, but I think it's also important that they have the facts. And as attorneys for towns and cities and villages and counties and so on, I think you are in a very important position to make sure that there is adequate fact-finding on these issues. So I truly do commend you for your interest in this subject and hope that this will be valuable. And now that I am officially retired from the practice, you know, if you call me, I can't charge you anything. So you're welcome to do that. Have a very good session, and welcome to the Jackson Center. As you may know, I'm on the board of the Jackson Center. We're very proud of this facility, and even more proud of the legacy that Justice Jackson, one of the greatest lawyers and judges in the history of the United States, came from here, and we're trying to preserve and enhance that legacy. Thank you.
As Randy indicated, I'm Mark Gorgos from the Binghamton law firm of Coughlin, Gehart. I was a bit intimidated when I heard that the Honorable Stanley Dean was going to precede me with some comments. I felt better when he said he couldn't stay for the whole thing. I'm most worried about him asking me questions. And so there's no mistake. Don't ask me a mistake question, because I'm really weak on that. My soccer background was mentioned. I've coached boys and girls soccer for a long, long time. But what wasn't mentioned was that I'm also, or was a certified FIFA referee. And municipal dissolution can be quite emotional, sometimes quite dramatic, and can even fray the tensions of a municipality. And we're going to have, I think, a very engaging panel discussion a bit later. And not knowing if it was going to get out of hand or not, I thought I'd bring my soccer jersey, my referee jersey. And I've actually got my yellow and red cards with me in case we need it. Although I got thinking, you know, we've got Rob Ray speaking at noon today, and how ludicrous is it to pull out a yellow card with something like a Rob Ray, say, Rob, you really shouldn't be doing that. You can keep playing, but don't do it again. I don't think it fits well with that particular sport. My firm has a nice connection with the Jackson Center, and this is a spectacular facility, and I'm really happy and humbled to be here. But one of our founding partners, Gene Gehart, of course, wrote two of the biographies of Justice Jackson. Greg Peterson showed me those books in the foyer, and you know, it's nice to be here. Greg told me that Gene Gehart actually gave one of the first speeches here at the Jackson Center. And as now the managing partner of Coughlin Gehart, it's very humbling, and I'm very proud to be here, following the legacy of certainly Gene Gehart, who was a great lawyer, and I know thought very highly of the center. Okay, let's talk about municipal dissolution. I'm going to give a background. Can everybody hear me? Okay. I'm going to give a background of you know, where we've been, where we are, maybe where we're going, and yet still save enough time for our panel discussion, where we've got, you know, three attorneys who've been right in the fray of it, and I'll moderate that. But let's first take a look at the experience of one village from Broome County, and you know, Stan indicated that in a recent survey, Chappaqua County came out fourth highest in real property taxes in the country. my county, Broome County, I think was 11th or 13th. We weren't that far behind. And so I want to spend a couple minutes telling you about the tale of the village of Johnson City, which is a village in my county, Broome County, population of about 14,000, incorporated back in 1892, located just west of downtown Binghamton. And here's the scenario. And these time frames are instructive in light of where we are now under the new municipal dissolution statute that we'll talk about. But in 2007, the village board received a petition from the taxpayers seeking dissolution. And in most municipalities, high taxes again certainly was the driving force behind that. Manufacturing had just about evaporated from the village. The village had really been founded upon the Endicott Johnson shoe manufacturing plant, which was a supplier of shoes in World War II primarily. So the village board gets the petition. In 2008, the village appointed a dissolution committee in accordance with the then Article 19 of the village law. They were assisted by the Center for Governmental Research, and if you are involved in this area of law, you have got to go to the CGR website. There is just a wealth of materials. They do tremendous work, and much of the materials, my handwritten materials that you got today, the factual data comes from them. In addition, the village had a shared municipal service incentive grant, what we call an SMSI, and here's what the study recommended. First, we're going to eliminate all 126 of the village positions, and those functions will be replaced by the town of Union, primarily, the county of Broome to some extent, and the village of Endicott to another extent. In essence, by the shift of those positions, 132 jobs gone from the village, 94 new positions created by the surrounding entities, a net savings of 32 positions. All village buildings and property would become owned by the town of Union. The town would take over public works, recreation. Village zoning would stay in effect for 2 years. The town would administer that, at which point there was going to be a unified study to try to bring the ordinances into alignment. Just the legislative and the overall government service function cost savings alone about $600,000. The village had a fire department. That was going to be abolished in favor of the fire protection district that would be served primarily by the neighboring village of Endicott. That savings alone, the elimination of the village fire department, savings of $1.1 million. Had a village police department. 18 positions would be eliminated. Those functions would be transferred to the county of Broome, the county sheriff's department. There would be a special police district within the village. Patrol cars would be marked specifically to show that those patrol cars were designated primarily to serve in the village for police protection. That elimination of the police department, savings $2.5 million. Water and sewer functions, of course, would go over to the town. Total anticipated savings from this dissolution and the transfer of functions accordingly, $4.6 million. The town of Union was going to get an aid and incentive to municipality grant. That funding would be annual, base of $1 million with annual increments after that. And the overall impact of this on a real property tax savings, which as we've heard before, is truly a monumental problem in the state. For the village residents, tax decrease of 29.8%, significant. And for the town of Union, which you think is going to have an upward tax impact because they're now taking all of these functions, a tax savings to the town of Union residents of 50%, primarily because of the grant, of course. So we've got incredible tax savings on an annual basis, what appears to be a logical transfer of functions, and what happened? That vote goes down on election night by 1 vote. 1 vote separates that. After absentee ballots are counted, the actual vote gap is 40. And so you wonder, okay, what happened here? It looks, if the primary driver of this are property taxes, and we're saving $4.6 million potentially on an annual basis, and maybe more with the cost of rising cost of healthcare benefits, salaries, etc. How could that have occurred? Well, we had a couple of things in Johnson City. My partner, Jeff Jacobs, who came out with me as village council, and he'll be on the panel as well. But Jeff will tell you, well, we had strong and organized union opposition from the police and the fire. We had public safety concerns from residents who weren't sure about response time, either from the county sheriff's office or from the village of Endicott for the fire department. And of course, overriding this was the historic loss of the sense of community. After similar defeats, most recently in August of 2010, in the villages of Williamsburg and Sloan, here's what Charlie Zepchik, who's the Director of Government Management Services for the CGR, said. The tax savings piece is very important, but not critical. If all you have is tax savings, it's still hard for people to see why they should give up what they've used to having. But if leadership provides a vision as to how things could be better as a result of this, you give people a more emotional desire to do this. And it's interesting that Charlie used the words emotional, because you wonder how emotion has an impact when people are really emotionally upset about real property tax savings. But as we've seen in Johnson City and in other villages throughout the state, there's more to it than just a rational connection of tax savings. There's got to be more. Now, we have had some successes in dissolutions. John Plum, who will be here with us at the panel discussion, would tell us that, Randolph, East Randolph, Perrysburg all has successful dissolution processes. And we'll look at some of those forces as to why it can be successful and why it can be successful. But if you look at that Williamsburg dissolution, where it was overwhelmingly defeated, in response to a poll question to residents, what would have changed your mind? If you voted no, what would have changed your mind to make you vote yes? You know what 87% said? Nothing. Nothing would have changed my mind. So you can see that we've got some pretty, some difficult foundational roots to overcome if we're in the municipal dissolution phase. I've been a municipal law attorney for probably 20 years. I'm also a school district attorney, so I see the push me, pull you on all these issues. And the question that I think we're faced with now is this the start of something big, or is this yet another non-starter, and where do we go from here if this isn't going to work? All right, let's just take a look. I don't want to be cognizant of time. How did we get where we are in this state? As I said in my handout, we've got in New York an incredibly complex layer of government. Although we're not alone, Ohio's got a very similar structure, but we've got 1,600 counties, cities, towns, and villages alone. We've got 685 school districts, and we've got 867 fire districts. That's an incredibly complex number of municipalities all trying to work together in an efficient, cost-effective basis. We're going to focus today primarily on villages and primarily on dissolution, because that seems to be where we have most of the emphasis today in trying to economize and streamline government. And I know we've got a mixed audience. We have a number of attorneys, a number of accountants, a number of public officials. So I want to try to make this still relevant to our lawyers, but also relevant to our non-legal community as well. Let's just talk about how you get incorporated as a village, and it's still happening today. To be incorporated, a village must have at least 500 inhabitants and have no more than 5 square miles. The creation of a village is really pretty simple. It can be done by a referendum of those within the area who want to be incorporated. And oftentimes villages get incorporated for a number of means, but the primary ones are they feel a sense that they need more services within a center part of the area. There may be disgruntled with town government, perhaps services aren't what they should be. I've even seen where an area has incorporated to keep out a specific development like a Walmart because they want to have zoning protections that'll create a buffer around the village proper, and if the Walmart wants to build out in the hinterlands of the town, then that's fine. Villages, unlike towns, can provide fire, police, water, and sewer services in densely populated areas. A village can still be in effect even if it goes under the 500 inhabitant level. And as I said in my outline, I left the blank. The village of West Hampton Dunes has all of 11 inhabitants. Of course, they've got a per capita income of probably $5 million per person in West Hampton, but nonetheless, it's an operating village and it's still on the books today. And as you can see, since 2008, we've actually had only 37 dissolutions in our state since 1920, and yet 125 new villages have been created. All right, the call for restructuring is not new. Certainly the Lundin Commission is probably the most well-known and certainly the most recent, but it really goes back some 20 years. We had studies back when Governor Rockefeller was governor with the Riley Commission. As early as then, 1990, those commissions were saying we need to more regionalize our governmental entities. We should be discouraging new village incorporations. That was followed by the Riley Commission, or the Consolidation Commission in 1993, which again said we need to do this more effectively. Let's start looking at shared services as another option. That was followed by the Pataki Task Force in 2002 and 2004, and that started to look at some more specific legislative burdens that are particularly onerous for municipalities. The Wicks law being one, that's one that calls separate bidding on HVAC projects, prevailing wage law, and other things such as that. And then, of course, the Lundin Commission that came out in April of 2008, which again recommended the need for consolidation, restructuring, and shared services. So we've been studying this problem for some 20 years. We've got property taxes that are leading the nation in escalation, and where are we? We are really now seeing dissolution efforts in earnest, more so I think, and certainly with more passion than ever before. And in the past, the obstacles for voters have been a fear of the unknown and a concern of the loss of services in their villages that they've known for so many years. And this can really be a connection, you know. If you get a speeding ticket and you're in a village, chances are good you know the village justice. They might have coached with you, you know, you might have gone to school with them. You may not know this same village justice if you get a speeding ticket in a town that's got a much wider population base and a much broader square footage base or square miles base. So there's a concern. Well, you know, I know these people. You know, I've been friends with them. If I need them, they're going to be there for me. They know who I am, and so that's certainly an obstacle that's difficult to overcome. And I think the question in all this becomes, how much are residents willing to pay for that familiarity? At some point you say every person's got their price, and that's really where we are in this discussion, I think, in 2010. What's the price that residents in any municipality are willing to pay for the familiarity with what they've always known? Before we get to the dissolution part, let's talk a little bit about some alternative approaches, and that's shared service agreements. It's certainly authorized under Virginia municipal law. You can have shared services agreements in municipalities. Essentially what they means is two independent entities, a village and a town, or a town and a town, and you can have all kinds of iterations from that, can share services, can perform services for each other if one and the other can each do that independently. Examples of shared services in my town include dog control, tax collection, we have some shared assessment functions. We even have a situation where the town of Concord maintains gasoline pumps, and they're used by the Susquehanna Valley School District because the district has an elementary school out in an area that's far away from their central bus garage. Other examples of shared services in your own communities? Obvious ones that maybe, I'm sure there's many. And you know what? Part of the problem is they go under the radar a little bit. They're not as glamorous. They involve some negotiation between the municipal lawyers and the leaders of those municipalities. But many times, the fact that two towns are sharing the services of a dog control officer never hits the media. And it just isn't glamorous. And it certainly isn't the kind of thing to inflame a passion saying, yes, now we're really doing something to make government more efficient, more expedient. We're sharing dog control services. That just doesn't have the same glitz and glamour of saying, okay, we're going to dissolve a whole village and move those functions somewhere else. So that's part of the problem with shared services, but I don't think we've left this area entirely and we'll talk about that later in the talk. Let's talk a little bit about the dissolution statute under the village law as it existed, because again, I think there's relevance into where we might be going. Again, village law Article 19 was in existence until it was replaced by the new Governmental Reorganizational Act, which took effect in March of 2010. And under the prior village law, you could have the dissolution really initiated in two ways, by the Board of Trustees or by the electorate. Not usually seen by the Board of Trustees, although not unheard of. The petition from the electorate in order to dissolve a village had to be signed by 1/3 of the eligible resident electors residing in that village. That 1/3 threshold is important. We'll talk about that in a bit as well. The process was, once filed, then the village trustees would look at it, make sure that the petition was properly signed, authenticated. Prior to taking many steps further, the village would form a dissolution committee. That dissolution committee, had to have representatives of the surrounding town, obviously representatives of the village, and the idea was to provide a thoughtful blueprint for how the dissolution process was going to proceed from that point forward. The study committee would hold public hearings. There was typically going to be good dissemination of the information in that report. And the plan for dissolution had to have 8 essential elements. How are we going to dispose of the property in the village? How are we going to pay for the obligations that the village now has? What do we do with the public employees? Are we transfer them? Do we eliminate those positions? What kind of existing agreements does the village have with the surrounding town that are now going to be taken over? How about our existing village ordinance and laws? What are we going to do with them? Is there going to be a grandfather period? How long are they going to be on the book? What kind of consistency are we going to have in their application? What village functions, essential village functions, are going to be continued by the town, and what ones perhaps aren't going to be continued by the town? Of course, most important, a fiscal analysis of the effect of dissolution on the village, and of course, on the surrounding town, and any villages who might also be impacted by the dissolution, and of course, the catch-all, any other matters that might be important. The existing dissolution statute assumes a couple of things. One, that the town is going to assume the duties. And recognize the town doesn't have, at least officially, an awful lot to say about that. They're not necessarily a party to the dissolution, but there's a presumption that the town's going to assume the duties. And in the case of the village of Johnson City and the town of Union, that wasn't necessarily a bad thing, because the town was going to have a significant reduction in their tax rate based upon a grant program. The cost of services after the dissolution, to the extent that there was going to be a direct correlation to those residents of the village, former village, being served, would still be a charge upon those residents within that district through special protection districts or special, legislative creative districts, what have you. And of course, for fire protection, the town board would have the ability, as they do now, to create fire improvement or fire protection districts. Because again, a town can't maintain its own fire department. You may say, well, I'm in a town and I've got a fire department. Well, it's not a town fire department. It's usually a fire protection district, and you're under contract between your town with a volunteer fire company to provide those services. So that's in essence the village proposition process that we had. And then of course we would have a vote based upon the referendum. And under the old law, even in that, what I would call a fairly thoughtful dialogue that, for example, Johnson City started in 2007 and ended with a vote in 2009, really a 2-year process. Even under that thoughtful scenario, dissolution votes in general face resounding defeat and continue to face resounding defeat in New York, with some exceptions. So, where are we today? Well, Attorney General Cuomo really initiated a plan for a revised consolidation dissolution statute. And there's actually an article in the paper today, I don't know if that got picked up here or not, and we'll talk about his perspective as to where we are today. But effective March 21st, 2010, we have the new New York Governmental Reorganization and Citizen Empowerment Act, and it really contains two parts, twofold, consolidation and dissolution. We'll talk more about the dissolution today. Again, pertains to towns, villages, districts, and special improvement districts, does not pertain to schools at this point, or cities. And just let me veer off course. School districts face a very difficult time, I think, in the rural areas with consolidation. I don't disagree with Stan Lundeen about the need to look at that. But I think in the rural areas, particularly where I am and maybe where you're from, there's a lot of logic for doing that. No doubt, decreasing enrollment, buildings underutilized, tax burdens escalating. The difficulty in school districts, I think, comes down to transportation. In my area, you would have potentially kindergarten kids who are on the bus from the western end of their current district to now the central part of an adjoining district on the bus for maybe 90 to 120 minutes. I'm not sure that parents are willing to live with that, although again, it then becomes a question, well, at what cost are you willing to pay for the tax savings that you're going to get, perhaps on a consolidation basis. So, schools have, particularly in the rural parts of New York State, their own issues getting away from the familiarity of what I know, who my bus driver is going to be, much like we have with municipalities. But the new law repeals entirely Article 19 of the village law, and the purpose of the act was this. We want, under the Act from the Attorney General's bill memorandum, to empower citizens and local officials to reorganize outdated and inefficient local governments. Well, that's laudable. I mean, I don't have any argument with that. And, the Attorney General obviously went through all through the data. We talked about how many special districts we have and how many layers of government. And the thought was, this law is going to facilitate consolidations and dissolutions by establishing a uniform and user-friendly procedure for all entities. What we had before is we had villages with a process, other entities with their own process. This is now a comprehensive consolidation dissolution statute that covers all of those available entities. And I think the intent was laudable. Certainly to, as they said, enhance the delivery of services, achieve savings, and reduce local property taxes and other taxes and fees. But I'm not sure that the intent of that was borne out in the actual legislative enactment, and here's why. Again, we're going to talk primarily about a dissolution initiative from the electorate, as opposed from the Board of Trustees, because again, I think that's probably more common. But I'll review briefly how it works with the Board of Trustees. The local board adopts a resolution and, much like we had before, will endorse a proposed dissolution plan, what they call a PDP, proposed dissolution plan. And much like the PDP, the dissolution plan under the old statute, it's got to go through and list the various factors that would be important to someone making an informed decision. A fiscal estimate as to the cost, what are we going to do with the public employees who might be your neighbors, how do we deal with the assets and the liabilities, what kind of agreements do we already have, shared service agreements that we've got to take care of, how do we provide essential municipal functions, and how do we interpret local laws, etc. Under the scenario, and I won't go through this in total detail, but it's in the handout, essentially we have this: filing of the petition, a resolution adopting the PDP, a 90-day period between the resolution adoption and the public hearing, a 180-day period, these are outside estimates, a 180-day period between the public hearing and the final adoption of the PDP. That allows you to make amendments, what have you, potentially have initial public or supplemental public hearings. And then from the adoption of the PDP, a 90-day process to the vote. So under a Board of Trustees initiated dissolution, under the new statute, we're looking at a process of about a year. Now, that has streamlined it. If you remember the example under the Village of Johnson City, that was in essence a 2-year process. And so in this context, we have made the dissolution process more expeditious and really haven't lost perhaps so much because we've got a pre-filed PDP. Under the new process for the electorate, this is when the Board of Trustees, either because of inertia or doesn't believe in dissolution or can't decide together that it's appropriate to do so, you can now have an electorate who again decides, well, we're going to commence the dissolution process. Here's what they need to do under the new statute. You now have to have at least 10% or 5,000 electors, whichever is less. Compare that with the prior statute under Article 19 of the Village Law, where you needed 33%. Now 33 down to 10%. The form of the petition is more liberally construed. We're going to be less concerned about the form, the signatures. I mean, we're still going to review them, but under the new statute, the clerk has all of 10 days to review the sufficiency of those signatures. From that point forward, the local governing board has 30 days to adopt the resolution scheduled in a referendum. The referendum must be held not less than 60, no more than 90 days from the adoption of that resolution. And if the referendum then succeeds, the local government board has 30 days to meet to get the initiation of the referendum or the dissolution process in process. So under this scenario, we've gone from 2 years under the old statute to under the new statute, a 1-year period under the trustee initiated plan to under this process. Petition is filed, 10 days, clerk reviews the petition, 30 days, board adopts the resolution for the referendum, and a vote thereafter within 90 days. In essence, a compressed schedule from 2 years to 1 year to, in essence, at the outside, and it could be less, 100 days. Now, that sounds great because you're saying, okay, we've got some clarity now, we've got a roadmap, we can really get these things, on the table and get them decided, and if it doesn't work, and let's just move on and not go through this angst of 2 years or 1 year of dissolution. The flaw, I think, and I'm not alone in this because certainly the New York Council of Mayors has raised some concerns about this. The flaw is, what happened to the plan? If you go back to what we originally talked about, and that was, well, emotion is going to be important here, and cost savings alone aren't enough. You've got to connect with the voters and show them, here's how it's going to be better. How are we doing that under the new guidelines? Because we've got no plan. The voters are essentially saying, okay, we had a petition that gets filed 100 days ago. I'm hearing how this might work, but there's no concrete explanation as to how it works, because under the new statute, the plan then gets prepared by the LGE after the dissolution vote has succeeded. And to me, that just seems to be a tremendous gap in the process that was supposed to be designed to make this more understandable and a more defined roadmap for voters to embark upon. Now, there is still a fail-safe if the plan gets adopted after the vote. So you've got a dissolution vote and the plan gets adopted, and you get the elector who says, well, wait a second, I voted for that. Well, maybe I didn't vote for it, and I really don't like that plan. This plan is not what I expected. Doesn't show me the kind of savings I expected. Doesn't assure me that I've got no loss of governmental services. I would not have voted for this had I known there's a referendum process under the new statute. And in essence, what that means is if you now have 25% of the voters who say, oh, I don't like that plan, let's do something different, they can then get 25% of the populace signatures on a petition presented, and then you have, again, a vote now on the plan that maybe we should have had before when we had the first vote. So it's not as though you've lost that ability to vote on the plan, but it seems to me that in legislation that's supposed to cause greater efficiencies, you've now perhaps set yourself up for 2 votes when before maybe you would have only had the 1. Other things that can happen on a dissolution plan that's been filed, let's say it's been presented to the board and the local government board, the village trustees say, we don't believe in this and we're not going to do it. We're not just going to dissolve our village that I've been a trustee member of for so many years. In that situation, any 5 electors within the village can file an Article 78. And Article 78 is essentially a tool used often in public law that can compel, a Supreme Court judge can compel a municipality to do something. Here the court will issue an injunction compelling the Board of Trustees to comply and in effect prepare a plan. Once that plan has been adopted, the trustee board then must use its best efforts to effectively wind down the affairs of the village. Under the new statute, we now have codified that 2-year period where local laws are going to stay in effect. And this is really essential. We've got to have this because if I'm a business owner in a village, I need to know that I'm in compliance with the sign that I've had in my village for years and years and years that might not be in compliance with the town sign ordinance. So you've got kind of a 2-year grandfather period where there's kind of a status quo, and hopefully during that period of time you get cooperation between the village planners and the town planners to try to meld those 2 code and ordinances books into one uniform statute. Outstanding debts and obligations of the LGE, the local government entity, still become assumed by the town, but still primarily get assumed by the property being served within the town. And that's, as we know it, that's our new municipal dissolution statute that I think has some gaps in it. Now, in the paper today, Governor, I said Governor, that's not right. Governor Canada Cuomo was talking about his consolidation plan, and again, as Attorney General, he was really the driver behind this. And he was asked about why are we seeing so many dissolution plans being rejected, both under the old and under the new law? And Mr. Cuomo says, well, it doesn't surprise me. Cuomo said the results. The instinct is I want to keep what I have, and this is my identity, and what is the alternative? And I don't know that people have felt comfortable with the alternative. Well, again, I'm not sure how you feel comfortable with the alternative if you don't know what the alternative is under the new statute. The scars from Johnson City, quite honestly, haven't healed yet. I was talking with Jeff on the ride out today. It's really only 12 months since that village of J.C. vote went down. Again, it was hotly contested and very emotional, and in many ways, tore that particular village apart. Johnson City, unlike, I should say, probably like many villages, has pockets of different economic levels. In that particular village, those residents who had higher per capita incomes were driving hard for dissolution. They thought it was a good thing. They might not have needed some of the services being provided to the so-called inner village residents. But when that vote went down, it resounded throughout the community, and I'm still not sure it's been healed yet. And you say, well, what role do school districts have? And oftentimes school districts are the unfortunate byproduct or bystander, or in some ways hostages to the dissolution vote, because the Johnson City School District, which is a district that I represent, in their budget vote in May 2010, following the dissolution vote the following fall, they saw their budget go down. And there was no doubt, listening to people from exit polls about the reason for that, and the reason was people say, listen, I didn't want the village to continue. My taxes are too high, my property taxes are outrageous. Okay, what's my next chance to make that impact known? It's the school tax vote in May, and I'm going to vote no because my taxes are too high, whether they're school, whether they're village, whether they're town, county, and I'm going to vote no just because of that. So, it certainly had an impact on the surrounding school district. In that district, the second vote, just before contingency budget, did pass, but not by a wide margin. And we still see remnants of the dissolution angst today. This was a letter to the editor in the Binghamton paper entitled, "JC Voters Must Choose More Wisely This Time." This was written by a proponent of dissolution who says, 9 months after the Johnson City dissolution vote, it's time to re-examine the arguments the majority of voters fell for. The election was a case study in how false claims, fear, intimidation, and deep union pockets persuaded voters to abandon a $4.5 million tax savings in order to enrich the overpaid Johnson City unions. A Robin Hood tale in reverse. So, again, a very emotional topic still in our area. All right, what can we expect from here? Where are we in this whole thing? As I said in my the title to this talk, is this a tidal wave of dissolution or just a passing storm? Again, as we said earlier, lowering taxes is not just enough. There's got to be more. We now have new legislation on the horizon. Again, the New York Conference of Mayors has criticized this statute. Back in March, really 2 weeks after this bill took effect, we had Assembly Bill 10432 and Senate Bill 7238 that came out, seeking some modifications, some tweaks, and some major modifications to the existing statute. That bill, when proposed, really has gone nowhere yet. It got referred to the local government committee. Probably the biggest thing that I talked about as being a gap in the current legislation is in fact addressed in this proposed legislation, and that is flipping the order of the dissolution study. It would again put the dissolution study when it's been initiated by the electorate before the vote. And the thought being that's really the way to a more reasoned approach. It certainly gives those people who are voting a better idea as to what they're voting upon. We'll have to see if this gets enacted or not. I've got to think that at some point when you have a track record of 80% of your municipal dissolution votes going down, that someone looks at it and says, well, it's either not time or the process isn't working. What should we be doing differently? And we'll certainly we'll be seeing more of that to follow. Okay, I think we're pretty much right on schedule, right where I want to be at least. What we're going to be doing in a minute is taking a brief 10-minute break. I'll get my panel members up here. In your package, you'll see a case study that talks about a theoretical village with issues. I'll take questions if we have any now, but it might be actually better if we wait till the panel gets up here. And as part of that panel discussion, I really want to have a lively interchange. I want you to be involved. I'm certainly going to open it up for discussions and comments from you as well. And I think we'll enjoy our time together. Any questions before we get to that? Yes, sir.
What would the tax savings have been without the grant?
For the surrounding town, would have been pretty much status quo. The town, as I recall, would not have seen a significant increase or decrease in their tax impact to the town residents. And again, the town is kind of, even under the new statute, the town is a weird sort of observer of all this. I mean, the town really doesn't have an obvious role in the dissolution process. They can't vote, and yet at some point the town gets all these burdens, responsibilities, things to provide thrust upon them whether they want them or not. And there is no doubt, for the town board, and if you're a town board member, I'd be thinking the same thing. Well, okay, it's one thing to have a public works department that we already have, and they're going to get all the equipment from the village, and they're going to get some of the manpower, and they'll probably be fine. And we've got the fire and police protection covered, but the essential government services, there's no doubt the town clerk, the town court, the town board members, certainly the town supervisor suddenly has a much bigger realm to govern than they had in the first place. And again, they don't necessarily have a role in the vote. Yes, sir.
Where did that $1 million grant come from?
That came to, it was a state grant. It's called the, I think, Aid for Municipal Services Grant.
Is that available to any communities that merge or consolidate?
Well, that's a good question. I believe it has been. What I don't know is it going to be under the 2011 budget?
That's not a guarantee.
It's not a guarantee as of right now that that's going to be available. I haven't seen anything that would suggest it's not gonna be available, and that grant is $1 million, at least for the town of Union, is $1 million base grant with increments thereafter. So you're guaranteed $1 million with the annual, cost of living, and what you say, increments going there for them.
What's that saving in taxes for everybody in New York State?
Well, that's a good question, certainly, it's glitzy,
Still smoke and mirrors.
well, that's a good argument. Other questions? Okay, let's take a quick 10-minute break, we'll get the panel members up here, and we'll take it from there.